Hi, this is Professor McLaughlin here to talk about the will preparation guidelines that you read about in Chapter 5. Wanted to break that down a little bit for you, highlight some of the more important ones, and ask you just in general to notice when the textbook is a little repetitive. So I found the guidelines repeated some basic norms for the will preparation multiple times. I know the book is very dense, and so I wanted to give you a little bit of help in maybe identifying and breaking down the massive amount of text that you're encountering and give you some tools for organizing that in your thoughts and also approaching it with a particular mindset. So I found the will preparation guidelines repetitive. They listed 14 or so, but 4 or 5 of them were all the same thing. So I wanted to give you this brief lecture and some resources for breaking that down a little bit. So some of the main rules of thumb for preparing the will. Hopefully, by the time you're reaching chapter 5, you're hearing some of the same things over and over, and you're encountering some of those typical scenarios where will drafting caused problems as the estate went through probate or as the estate didn't go through probate, whatever the case may be. So always including a residuary clause is a rule number 1, and that prevents leftover items, cash, property from escheating to the state, from just going to the state of California. We want to make sure the testator's will is adhered to, the testator's intent is complied with, and the residuary clause, well, let's just put it this way, very few testators or testatrixes, testatrix are going to donate to the state that they die in. And so the residuary clause helps whatever is left over, whatever was not anticipated to be left over, to go somewhere. We want to avoid ambiguous or unclear language. We want to identify everybody very carefully. We want to identify beneficiaries carefully, and we want to use simple, straightforward language and work as hard as possible to avoid any ambiguity so that there's no contest to the will. And then another good rule of thumb is to have witnesses chosen carefully and make sure they know what might be expected of them. We don't want to have conflicts of interest. We want to have individuals who will understand that they may have to testify if there's a will contest, and witnesses who are competent and understand what they're doing. So a couple more guidelines. I'm using the numbering that the textbook authors used. Making sure that the word processing and computer printer typeface, this is kind of old lingo, is the same. So wills are problematic if there's odd scribbles on it, or there's fonts that are different. If somebody cut and pasted and it doesn't quite look right, it looks like perhaps the will has been changed, the will has been adjusted in some way. And so a good rule of thumb for you as students, because we all can tell when the font is changing, as you are processing anything in law, but particularly a will, that we're using the same software. A lot of this is achieved already through however the estate law firm has set up the word processing, but it's worth going through it so that we understand the thinking behind it. We want to make sure everything's uniform, that nobody can be accused of making a change. We don't want anything to look suspicious. Also, don't leave odd spaces where a beneficiary, a disinherited child, or someone might do something wrong and write their name in or be able to type something in to the will. And there's a lot of, when you look at how powerful computing is and computers are and software can be, people are super talented, a lot more talented than I am. Another guideline I thought that was worth talking about is placing small estates in joint tenancy. I wanted to talk about this one because it hits a couple of important things that I think warrant explanation. So a small estate where we don't have a lot of property, we don't have a lot of personal or real property or any real property. Let's just avoid probate altogether and have that cash, that money held in joint tenancy. And here you could also put a caveat, or listed with a beneficiary already. So I wanted to hit a couple of concepts. A small estate is what you and I have right now. Not a lot of assets, and maybe some devices and digital assets that we want to leave to loved ones. We put things in joint tenancy with a right of survivorship or joint tenancy. And this is where our chapter 1 really focused on how things are held, what property is, but how the property is held. Is it held jointly? Joint tenancy can allow the property to pass automatically without having to go through probate to the joint tenant. And additionally, avoiding probate is always the goal, because probate takes time. In Orange County, I'm told, can take up to 24 months, even longer if there's a problem. So avoiding probate is a time saver. It's costly. There are going to be things that need to be filed, and we want to achieve, as we're preparing the will for the testator, the ultimate goal of passing assets to the intended beneficiary. And also, you may remember early on we talked about will substitutes, having a beneficiary listed on an account, having things held in joint tenancy, so it avoids probate. Another really important part of the will preparation is making sure that the data on the beneficiaries and devisees is current. You have current addresses, phone numbers, the relationship to the testator, testatrix. And if the devisee is a corporation or a charitable organization, that the corporate name and address should be given so that the personal representative or executrix is able to clearly identify who the funds should go to. So Auntie June wanted to tell you a little story. I don't frequently talk about some cases that I am involved in, but this I think I can talk about pretty freely. I've changed the names and redacted and edited what I'm about to show you. But this was not a case I was hired as an attorney to work on, but I sit on the board of directors of a nonprofit called Hope Center for the Arts. And I put a hyperlink here for you to go visit it. It's a great organization. I have an adult child with disabilities who's very artistic, musical, does video, has his own YouTube channel. And this organization, like many nonprofits, encourages donors, potential donors to the nonprofit, to include in their will a gift to the organization. And you could, for many people, the residuary could go to a nonprofit. But in this case, there was a decedent, Beverly, who had a sister, Melissa, with intellectual disabilities who attended Hope for years, for decades. And Melissa will attend Hope until probably her own death. Melissa is disabled, but Hope teaches visual arts, performing arts to the disabled and exhibits that art, and they get paid for performances, and people who attend Hope also get 50% of any art sale or performance fee. So Beverly has a sister with intellectual disabilities who attends Hope. Beverly passes away. Her will creates a trust that is going to take care of Melissa, the beneficiary of that trust. Also in the will, Beverly leaves a organization called Hope University Anaheim $100,000. And Beverly passes, and now it's the duty of the trustee to find the correct beneficiary under the will. The trustee is told that the proper beneficiary is Hope Center for the Arts, but the will describes an organization called Hope University Anaheim, and the trustee sends the $100,000 to Hope International University. Let me move my big head. So how is Hope Center for the Arts going to get its money? The reason I tell you this story is because maybe the missing element here is maybe the will needed to be updated with a new name. Hope had changed its name legally before Beverly had passed. So this is an argument for making sure the will has all the beneficiaries and devisees' proper name. But one thing that Beverly did correctly, or the lawyers who advised Beverly or drafted Beverly's will correctly, is that they put the Hope EIN, the employee identification number for the corporation, for the nonprofit corporation, was included in the will. And just like a social security number, the EIN is unique, and no two organizations have the same EIN. So what I'm showing you now is my letter to the trustee. It was an email. I spoke to the trustee. He wasn't going to budge, and he thought the other organization, even though it did not have the EIN number that was stated in the will, it did kind of have a similar name. So clearly the decedent, there was some confusing language. You can take a look at this. I just wanted to show you the whole communication. We were working hard to convince the trustee that a mistake was made. All of us had spoken to the trustee, and he was not budging. And so I wrote this communication. Also, we were really working hard to get in touch with the law firm that was helping the trustee. And I crafted this communication. Oh, snap. Pardon the rough production value, but I crafted this communication with how do you think you can remove a trustee? So we had a trustee who was insisting that a mistake was not made. The money was given to an organization with a name similar to how it appeared in the will, but did not match the EIN number that appeared in the will. And we had spoken to everybody, the organization that received the money and really wanted it, but also wanted it to go to the right place. And we also talked to the lawyer, but this communication was sent with the intent to let the trustee know that we were going to claim that the trustee had breached their duty and had made gross and negligent errors, which is a way to remove the trustee. And at the end of the day, everybody got on the same page, and the trustee provided all the documentation necessary to get the money back from the other organization, and eventually the funds were given to the proper organization. So I wanted to wrap up with taking a look at the end of chapter 5. There's one case problem. And after considering the guidelines, taking a look in chapter 5 at the guidelines, wanted to see if you felt like going on the little journey with me to say what are the problems with this will that you see. Hopefully you're worried about some obvi problems, which is that things have been crossed out and maybe typed or handwritten in. That's problematic. There's no signature. There's no date. This is not a holographic will, so let's assume we're in the state of California. There are no witnesses who have attested or signed. There's no residuary clause. If you take a look at clause 4, there's an attempt. I give my beloved wife, Althea, my interest in our home that we own jointly. So the testator cannot bequeath what is not solely theirs. If the home is owned jointly, it will pass to Althea. It should not be in here. It doesn't identify the executor. It doesn't give a name for the executor. Let's see what else. There's a couple of other problems. There's some ambiguity about what is left to Curtis, and Curtis gets all my personal property. There's a problem with 3, and some ambiguity there about all my other personal property going to Curtis. Let's see what else. I think that's it, but I'd be interested in, did I miss anything? Is there anything else you think is problematic about this particular will? Let me know. Alrighty, that's it for now. I'll see you more online.